Now, for a reaction to the Pretoria High Court's judgment on Tuesday, we're now joined by Home Affairs Minister Dr. Aaaron Motsoaledi. Dr. Motsoaledi, thank you so much for your time. But before we even get to your reaction, perhaps we can start by explaining blocking of IDs and why this was being done in the first place.
Yeah, good evening, Martha. Good evening to the listeners and viewers out there. You will realize that we were expecting this judgment because even before the court said, we considered that the business of blocking IDs is not provided for in law. It might be serving a good purpose as it does, even the judge said so. But the biggest problem is that there's no law in the country providing for it. So even before the court case, I have already given instructions to unblock people's IDs. And there was a total of 2.5 million. They have already unblocked 1.8 million of those IDs. Now 700,000 were remaining. Unfortunately, it was a bit complex because we have not finished investigations on them. Even the banks of the country, through SABRIC, the structure that deals with risk in the banks, said if those 700 are just unblocked willy-nilly without finalizing our investigation, the banks stand to lose 17 billion rand, not 17 million, 17 billion. That's what the banks told us. So we went to the court to plead with the judge. If you look at our prayers, we said we are aware, we are conceding that this practice of blocking IDs is not provided for in any law, but please give us some time so that we deal with the 700. And the judge gave us these 12 months. That's why we believe we're granted what we're asking for. So it's not a debate that we knew that what we are doing is not in the law. We knew about it and we've already started correcting it. Now, coming to the issue of what is blocking IDs, Martha, in 2005, when Home Affairs introduced a system called HANIS, Home Affairs National Information System, which is an electronic system that stores biometrics of people, photos and fingerprints, they started discovering a lot of discrepancies in these issues of IDs. So they started doing two things. Number one, they started taking or flagging IDs. In other words, when they discover some mistakes on your ID, they flag it with the hope that wherever you appear with your ID, they'll realize that your ID is flagged and send you back to Home Affairs to rectify the mistake. It might have been a mistake of double IDs, or two people having one ID. Sometimes a mistake where it shows that the man is married to two different women at the same time. Not in terms of a sort of bygamy, whereas they were not married in terms of the laws that allow polygamy. So all those were corrections. Now come the biggest one, where they believe that you acquired your ID fraudulently. Then they block it and start investigations. What the judge said is you can't do that, and we agree with the judge, of course. Investigate first and follow Paja. Now, I must concede strongly that officials in Home Affairs, for a long time, we've been trying to teach them about this PAJA, provision of just administrative action, which is one of the central laws in the country, that before you take administrative action on an individual, you need to send them letters of audio alteram partem. In other words, they need to be informed that we are going to take this action on you and what you have to say about it. It's just like when you suspend a person in government. Even if they've committed a heinous act, before you suspend them, you write them a letter of audio so that you hear what they are saying. And this is exactly what was lacking. That's why the judge made the judgment that she has made.
And one can appreciate your concession there, Minister Motsoaledi, but also what the judge has said was that while they also acknowledge that 1.8 million IDs have now been unblocked, and I think about 700,000 remain in the system that you've just brought up as well, to say those also still need to be investigated. What the judge also said was that not only did Home Affairs jump the gun, but even though you're unblocking these IDs, it's very little consolation for those who have been affected by these practices.
Yes, of course, we knew that and we accept. We accept it, and as I'm saying, long before the court case set, we have already considered. I personally am the one who instructed officials that please, you can't block IDs even if it serves a good purpose for the security of the country. The problem is that there is no law that covers you. There is no law that instructs you. That's why they started this process of unblocking. And of course, by the time they unblocked, people have already had their IDs blocked for quite some time. So we do concede that that's why the judge said they have to arrive at this judgment. And also the reason that it went to court finally, even after conceding, are two. The applicants were insisting that they want a judgment so that it gets recorded. It's not just conceding. They wanted it to get recorded so that it forms a precedence. But two, on our side, as I said, we're also going to plead for the judge to give us some time to deal with the 700. And we are happy that she has granted that, because this 700, we don't just want to unblock them before finalizing, because the banks want us. Nobody, even yourself, I don't think even yourself, you like the banks of the country to collapse like that.
Now, and also, as you mentioned, Minister, there were good purposes for these practices of blocking, not necessarily not alerting those people, but for blocking. And when you are wary or alerted of perhaps criminal activity, moving forward, how will the department then deal with such cases where there are suspicions of perhaps criminal activity, or the banks have raised their suspicions as well? You've mentioned numbers of over R1 billion that could collapse this economic industry because of such a matter. Moving forward, considering this judgment, how will the department then handle these matters?
Remember that the applicants were asking the judge to declare the practice of blocking or flagging IDs unconstitutional. If you read the judgment, the judge did not do that. She said it's unconstitutional in as far as certain procedures are followed, and specifically PAJA, fair administrative action, or a process of investigating first before you block. So she did not rule out the issue of blocking. What she was asking, follow normal procedures. So all that Home Affairs have to do is to follow those normal procedures. We did discuss these issues, but officials were panicking. They were saying, look, if a person has defrauded the ID, and by the time you give them a notice that you are doing something, they might rush to the bank or do another transaction, which we may regret. That's what they were saying. So which means, while we are going to follow these procedures in terms of PAJA, we've got to go back to the drawing board and look how we redraw this law, such that we have got a law, how we redraft this law such that we do have a law in the Identification Act or any other act that actually helped us. Fortunately, you are aware that we are having public consultations about the white paper, where we are saying we are going to relook at the Citizenship Act, the Immigration Act, the Refugee Act, and Identification Act. Somewhere when we reenact those acts, we must place somewhere where this issue of defrauded IDs or something being wrong in our ID is covered for, so that we don't work outside the law.
And also, Minister, the court also said that Home Affairs may not prevent a child's birth from being registered because the parent's ID is under investigation. What are your thoughts of that? Because they're saying in these circumstances, Home Affairs should register that child as a citizen or permanent resident of South Africa in spite of their parent the ID being investigated.
Well, the general law in South Africa is that whatever decision you take, it must be in the best interest of the child. So it's not something that is new to us. You have to take a decision that is in the best interest of the child. We've had situations where, as you might be aware, in schools, for instance, that we cannot bar a child from going to school because they are not documented. And here we are talking about South African and non-South African children alike. There are those who are not documented for whatever reason, we agreed, even with Minister Njimosera, that we can't stop these kids from attending school while we are dealing with the issues with their parents. And after taking that decision, the High Court in Gqeberha also arrived at such a judgment that we cannot bar children from going to school, but we'll deal with the issues and deal with them later while they are at school. So as I'm saying, it's nothing new. The part that is very painful, and I don't want to hide it, Masa, is when a man has defrauded the country and got fraudulent documents, but arrive here, impregnate a South African woman and has a child, and we take action about that fraud, and the court says, no, you can't send this man away because he has already got a child in South Africa. So even on behalf of children, we do have fraudsters who stay in South Africa, even though their stay here is through fraud. But the court says because there's a child involved, charge that person for fraud, but you can't send them away. So we've already been doing that. It's a painful thing, but it's a law. It's a law, and we've got to follow it.
Very tricky one there. Well, thank you so much for your time and all the best to you. That was Home Affairs Minister Dr. Aaaron Motsoaledi.